Our presenter today is Janelle Stanton. She is the senior associate here with the employment law team at Wagner, Falconer and Judd. She brings over 9 years of employment law and business litigation experience to the team and dedicates much of her practice to counseling business leaders on maintaining compliance with all of those federal, state, and local laws. She's our favorite thought leader to have around, and we're excited to have her share with us today. So again, thank you everyone for joining us. And with that, I'll hand things over to Janelle.
All right. Thank you so much, Sophie. And thank you to everybody for being here with us today. We're going to talk about all things independent contractors and talk about some of the common misconceptions that we hear on the team fairly frequently. We'll talk about some definitions, why the distinction between an employee and an independent contractor is so important. Then we're going to dig into exactly what Sophie mentioned, all of the various independent contractor tests. Just kind of a hint, there's a lot of them. And now there's a new one that was effective as of March 11th of 2024. It is in place now. That could change over time, but for now that test is in place. And then we'll talk about the next steps for compliance. So to dig in, and like I said, we hear these on the team quite frequently, and so I want to take some time to debunk some independent contractor myths. Throughout the presentation, you'll see me refer to independent contractor as IC. I sometimes just get sick of typing independent contractors, so I've abbreviated independent contractors IC throughout the presentation deck. So I think the first one is one of the biggest ones we get. Well, we've got an employee, they're a full-time employee, and they're going to go down to part-time. Maybe they had a kid or they're getting close to retirement age. And so we're going to reclassify them as an independent contractor because they're part-time. And that's a big no-no, especially if that individual is going to be doing the same work for your company that they were doing previously. Just simply going to part-time does not make them an independent contractor. And when we go through all of these tests, you're going to see that, oh yeah, whether they're full-time, part-time, what have you, has no bearing whatsoever on whether somebody is properly classified as an independent contractor. Another one that we hear is a 1099 employee. People refer to folks as a 1099 employee. As you'll see in just a moment, that is not the case. That's actually a 1099 an employee. You're putting two different ideas together that don't work. Somebody cannot be a 1099 employee. If you are issuing a 1099 to somebody, it's because they're an independent contractor and they should be properly classified as such. An employee is somebody who's issued a W-2 and enjoys a whole host of different benefits, which we'll touch on in the next screen. Another one is people think that small businesses are exempt from these classification rules. I'm not actually quite sure where this one comes from. I guess it's because people think, well, you got to be 50 employees for the FMLA. You have to be 100 employees for EEO-1 reporting. So we're small. It's okay. Small businesses, there's no small business exemption. Again, you'll see that from the tests that we're going to cover in the later portion of our webinar today. With COVID-19, a lot of people started working from home, and a lot of employers then reclassified those folks as independent contractors. And so there is this thought or this concept that, well, remote workers are automatically independent contractors. And again, not the case. And I know that for a lot of companies, when you send employees to work from home or when they're working remotely, there is a whole host of new employment laws that you have to be aware of. If your employee is going to go work in New Jersey or New York or California or Massachusetts or even Georgia, there are a host of different laws that apply. And if they're employees, that's the case. And there's lots of things that you need to be thinking about and working through before you allow employees to work remotely. So a lot of employers thought, well, this seems like a good way to avoid having to deal with all of these multi-state employment laws. And that's true if somebody is properly able or is able to properly be classified as an independent contractor. However, remote workers are not automatically independent contractors. And anytime you are reclassifying an individual from an employee to an independent contractor, I would expect to see a very significant change in the way that that individual is performing services for your company to ensure that that person can be properly classified as an independent contractor. Because if they're, again, just doing the same job for you, but less hours or in a different state, that does not an independent contractor make. The last two are my personal favorite misconceptions that I hear, and I have talked to many clients who are like, well, this is just how my industry does this. This is how the construction industry does this. This is how the manufacturing industry does this. Everybody is classifying these types of positions as independent contractors or these types of workers. Great. I love that. But let somebody else get sued for misclassifying, even if it's the industry standard. Again, that is not part of any of these independent contractor tests. And this kind of dovetails into the last one. An audit's not really likely. I don't need to worry. Maybe you're not in an audit heavy industry. Audit heavy industries are retail, construction, things like that. So maybe you think, hey, we're just a small office. What's the worst that could happen? Well, there's a lot of different ways that these types of audits can be triggered. So let's say you had an independent contractor that you terminated, and they go out and they file an unemployment claim. So they apply for unemployment insurance, and they list you as their former employer of record. And if you come back with, no, they were an independent contractor, this can start that audit process. If you have a worker who's injured in your workplace and they claim that you're their boss and that you were their employer, again, this will start the work comp folks to be in your business about, hey, was this person actually an independent contractor? Somebody could be just upset. There's people are much more educated about these legal issues than they used to be. So if somebody's like, I'm not getting benefits, I'm not covered by unemployment insurance, I'm not protected from anti-discrimination laws, this isn't right. They might go out to the Minnesota Department of Human Rights, the U.S. Department of Labor, or some other federal or state agency and make a complaint about you. And so then again, if you end up having this agency in your business, looking under the hood and poking around and seeing what are these relationships like with your workers, that is something that can also lead to an audit. So it doesn't even have to be that the Department of Labor just shows up at your doorstep. I mean, typically these things are raised by somebody who's disgruntled, somebody who's been let go, their contract's been terminated, something like that might lead them to say, well, wait a minute, was my relationship really one as an independent contractor? So this is probably the most important slide of the whole deck. And, we can certainly make sure, I think, Sophie, that we send out the deck to everybody in attendance because there's a lot of text here. But these are really, so this is not the test, right? The tests are going to be coming up, but these are the typical features of a worker who's an employee versus a worker who's an independent contractor. Employees, and this is again general, you'll see all of the tests are slightly different, but generally an employee is somebody who is subject to significant oversight by the company, somebody who's subject to performance reviews, who is trained in, who's given an employee handbook to sign, who their daily work and progress and work toward goals and KPIs is measured, that is somebody who is more likely to be an employee. If your company is controlling the method and manner of work, that is somebody who is most likely going to be properly classified as an employee. We really need to think, kind of wrap our heads around this, because an independent contractor is somebody who comes in, they do their thing, they do the work the way they want to do it. And really, there shouldn't be anybody outside of, maybe specifying what the goals are, what the outcome should be. There really shouldn't be somebody at your company monitoring that individual's way of doing their work and their different methodologies. Employees are paid wages and are eligible for company-sponsored benefits. They are subject to continuous employment. So as long as they're performing tasks that are required, they are, typically, unless business factors dictate, are going to be continuously employed. Income taxes, Social Security, Medicare, those are all withheld. That employee is economically dependent on the employer. They don't have their own business. They aren't obtaining this type of work from other companies. And these folks are protected by applicable employment laws. Unfortunately, independent contractors are usually not protected by anti-discrimination laws and other things. So independent contractors, and the example I always give, the most classic example I can think of is you're a firm, you're a law firm, you're any kind of company, and you're like, hey, our website looks like it's from 2003. We're going to need to update this. We don't know how to do this. We're going to bring in a web design company. They're going to be independent contractor. We're going to put a contract in place. They're going to help us with our sad state of our website. And once the work is done, they're going to go on their way, and in the process, they're going to probably be doing work for any number of other companies, potentially any other number of competitive companies to you. And those individuals are engaging in and providing services in exchange for compensation. They're not employed by any single company. A website design company, they're going to be, hopefully, if they're doing very well with their business, they're going to have multiple different clients that they're working through website design with. They have economic independence. So they are not reliant solely on the work from your company to maintain their livelihoods. They are engaged for a specific term to perform an identified service or task. So they're not coming in to be your outsourced IT team and do repeated work and whatever else. They're coming in to perform a specific task for your company. They retain full control over the method and manner. Now, of course, giving them a scope of work with identified, work that they need to, or deliverables that they need to provide, that's fine, but you're not in there telling them how to do their web design work. They're responsible for paying all of their own income tax, Social Security, Medicare taxes. They are going to get a 1099 NEC for their income reporting purposes. They can work with other members of the public. Now, I have seen some companies try to put independent contractor agreements in place that have non-compete agreements. In and of itself, a non-compete agreement isn't going to fully destroy the independent contractor relationship, but it does typically tend to seem like if you're having a non-compete, then they are more of an employee. Now, reminder, in Minnesota, non-compete agreements are prohibited for both employees and independent contractors, which is unique. So in Minnesota, you can't do it anyway, but if you're in another state that still permits non-compete agreements, I typically say that, look, that's a feature of an independent contractor, is that they can perform services for anybody. Now, could you put a non-solicitation in place where the independent contractor, when they are done with their work, they can't poach your amazing employees? Sure. Yeah, you can do that. And again, they often own their own business and provide services according to their own terms. So these are really the key differences between employees and employers. And I can't tell you how much none of these things matter. Their title, just because you call them an independent contractor, it matters zero. If the independent contractor chooses the relationship, that doesn't matter. And again, I hear that a lot where clients are like, well, this is what they want. They want to be an independent contractor. They want to be able to come and go as they please, do things on their own terms. And I'm like, that's fantastic. I love that for that person. But it doesn't matter. What matters is the relationship and the way that that person provides services for your company. The existence of an independent contractor agreement. Now, again, in the tests that we talk about in a few slides here, you'll see that the existence of an independent contractor agreement is one of the factors that might indicate that person is properly classified as an independent contractor, but it is not the be all end all. And simply, invoicing somebody versus putting them on your payroll, that pay status is also not a factor that would determine whether that worker is an independent contractor. Now, how somebody gets paid can be, again, one of the factors that you look at, but it is not, again, determinative. And you'll see from the tests that the tests are tough. There's nothing really not one real factor that's determinative anywhere, but a few things just to kind of point out. So why is this a problem? And I'll tell you, there's a lot of reasons that this can be a problem. First of all, if you are misclassifying an independent, a worker as an independent contractor, independent contractors are not eligible for overtime, and you're probably not tracking their hours because, again, all we care about is the end product, the deliverable, what the services they are providing for your company. Are they doing that? So you don't care if they work 60 hours in a week or 10, as long as they're doing the work, that's fine. But if you have improperly classified that worker as an independent contractor and they were actually an employee and they worked all this overtime, now you've got a wage and hour issue on your hands where you have, maybe not paid the minimum wage. Maybe you recorded their time, so you don't know how much overtime they've worked. You've probably missed many statutes record keeping requirements as far as paid sick leave, as far as providing pay stubs, all of that. You've not done the appropriate tax forms because you've not been withholding income tax, Social Security, Medicare, all of that. You may have looked at them and said, hey, you're not eligible for FMLA. If a worker comes to you who's an independent contractor and they're saying, I have surgery, I'm going to need some time away from work. And you're like, well, we need this deliverable turned around. We're going to end this contract with you. If that person was actually an employee, maybe you've missed the FMLA now and you have actually retaliated against them because they have rights under the FMLA. Or an independent contractor comes to you and says, hey, I've got a disability. I'm going to need some accommodations to the way I do this work. And you're like, hey, you're an independent contractor. I don't think so. We're going to end the contract. Again, you may have now retaliated and failed to accommodate under the Americans with Disabilities Act. You also might have work comp and unemployment issues because if you're not paying premiums to work comp, so that person is not covered and they're injured, and then it turns out that they are an employee, well, now you are personally on the hook to pay work comp out of pocket because they've not been covered. Same story with unemployment. So this can become, it's not just one penalty. Oh, I'm going to get a fine. Although certainly, I already covered this. Certainly there are monetary fines. So you may miss all these other compliance pieces, but you can also get seriously dinged with a lot of financial penalties here. You might owe back pay, including overtime compensation. That can be for a period of up to 2 years or 3 years if the courts are, find that you have engaged in willful misclassification. It could go up to 3 years potentially. You might have to make right retirement benefits, health plan coverage, disability payments, tax and insurance obligations. Then there's also liquidated damages and civil monetary penalties. So I can't underscore enough that getting this right is really, really critical. The failure to properly classify folks is just disastrous. Um, oh, I guess I covered most of this, but you could also, if you have employees in a state where you're required to reimburse work-related expenses, and there's a couple handfuls of states that require reimbursement of work expenses, Illinois, California, and you haven't been reimbursing those, you could be subject to a claim for that. I talked about the ADA and FMLA. Let's say you do a mass layoff and you have requirements under the Federal Warren Act or any of its state equivalents. If you're not counting that independent contractor or independent contractors, if you're making use of multiple independent contractors, you may not be counting them toward that 100 employee total under Warren, or even less under that state equivalent. Same thing with Title VII, the ADEA, the Age Discrimination Enforcement Act. You might not be counting your independent contractor to that 15 employee number under Title VII, and you might be thinking, well, the anti-discrimination laws under these federal laws, they don't apply to us. And that may not be the case. So you can kind of get the sense there's a lot of potential penalties. I think what probably complicates this the most for people is the fact that there's not one standard test. So typically, when I'm doing these presentations, we might have two different tests. We might have something that's one way under federal law and some nuances for state law. That's pretty common. But here, there are different tests depending on different laws and different agencies that might be involved. The FLSA standard, the Fair Labor Standards Act, obviously that is the law that governs wage and hour matters for employees. So there is the economic realities test under the FLSA. So if we're talking about the fact that you didn't pay minimum wage or there's a unpaid overtime claim, they're going to be looking at the FLSA economic realities test. If the issue is relating to taxes and the fact that you've not withheld income taxes, Social Security, Medicare, all of that, it might be the IRS who is enforcing the misclassification issue against you. So the IRS has what's called the control test. There are also common law tests. So there's the test under the National Labor Relations Act. There's the Darden test. There's also state and local tests, and we'll talk about those too. And of course, the primary crux for our conversation today is the Department of Labor's new test, and we'll talk about that too. But I do want to give you a flavor for all of these different tests. I think you'll kind of start to see the similarities amongst the tests, but it is worth noting there are slight differences to each one, and they are examined by courts in different ways. So again, if you're facing down a wage and hour suit, you're going to want to know what the FLSA economic realities test is. If you're facing an IRS audit, that's a different test that you would look at in that instance. And we'll talk more at the end about how to square your independent contractor relationships with all of these variety of tests. So with FLSA economic realities test, the courts will analyze the totality of the parties' relationship, and nearly all courts are using a balancing test when they evaluate these various factors. the degree of control is really paramount. That is going to be looking at the degree of control that the company has over the worker performing the services. So in an employment relationship, the employer controls the manner and means of the work. But if the worker is properly classified as an independent contractor, that contractor controls the work. They control, the company can control the result, but not how the work is actually performed. That is the focus of this inquiry. So when we say control over the manner and means of work, this means that the independent contractor is the one who establishes the cost of the work to be performed. Now, there can be negotiation in that. Maybe the web design says it's going to cost you $50,000 to get this website from us, and you're like, that's wild. I don't want to pay that. Let's cross these things out. Can we do this for 30? And then the independent contractor can negotiate back and forth, but essentially it's the independent contractor who sets the cost, who says, yes, I will agree to that, or no, I won't. This is what the work costs. Independent contractors hire and fire their own workers. So if you've got a truly properly classified independent contractor, they can have their own employees, and they can farm out some of that work to their own employees. And that's completely proper in that specific type of arrangement. They can delegate tasks to those individuals. They're responsible for their own licenses, taxes, administrative obligations, things like having their own workers' compensation insurance for their employees, their own unemployment insurance for their employees, their own other insurance, general liability insurance, all of those things. Those are the responsibility of the contractor. The contractor does their own advertising. They prepare the work schedules. And they're not given that close supervision or required status reports. Now, again, an independent contractor, there's going to be, sort of that punch list or work list that they're going to be working off. And I would expect in a properly drafted scope of services that you're going to see, in 2 weeks, they're going to do this. In a month, this deliverable will be complete. So, I mean, those things, checking in on those doesn't destroy that proper independent contractor relationship, but typically they know what needs to get done. They're working on it, and they're meeting those goals and deadlines. The economic realities test also will look at the relative investment in facilities. So they really should not have much property at all of the employer. So they should have their own place of business, their own, mailing address, their own, if they don't have their own office, they should have their own equipment, or much of their own equipment to be able to provide these services. So what is that investment in those facilities that they've made? Does the worker have true opportunity for profit and loss? With an employee, if I'm terrible at my job, I can lose my job, and I could be subject to a pay cut or a cut of my hours, right? So there is, in a sense, with an employee, this possibility that you could suffer some loss, but it's not truly the same as profit and loss in the sense of an independent contractor. An independent contractor has to have full agency over that opportunity for profit and loss. So it has to be on the back of that independent contractor as a burden to them to be the one solely interested in and responsible for making their business profitable and avoiding any monetary loss. You also look at the permanency of the parties' relationship. So again, an employee is somebody who is hired on with the expectation that they're hopefully going to be there for a long time. You make a lot of investments in them. An independent contractor is typically coming in to provide some finite service or deliverable for your company. And then once the work is done, they go. They also look at the skill that's required in order to provide the services. So does the independent contractor have a unique unique skill set to achieve the outcome that they've been brought in for. Again, you're not going to hire somebody who is, a coder to come in and do web design, right? They're different things. So does that person have the skill required to do the job that you've hired them for? That is really the crux of that economic realities test. And again, if you're hit with a wage and hour suit for failure to pay minimum wage, failure to pay appropriate overtime, this is the test that you would be examining in that situation. All right, so the IRS has a totally different test. And here there is kind of three components. And many of you may have been I did a presentation several years ago about the IRS test. And at that time, the IRS was still using their 20-factor test. I know, 20 factors, my God. It's kind of still in a 20-factor test, but they've tried to distill it down into three main components. And again, you're going to start to see these similarities. So the IRS control test, again, this comes up in the context of failure to withhold income taxes, failure to make those payments, into the IRS as you're required to do. So it's behavioral control, financial control, and then the type of relationship. And you'll see each of these three components has multiple layers underneath. So it is kind of a 20-part test, but I guess they thought this sounded more interesting or sexier. I don't really know. Behavioral control. So they're looking really at four things here. They're looking at the type of instructions given. Are you saying you need to work these hours Monday through Friday? You get a 30-minute lunch at noon. And here's our policies. This is what you need to do. So what are the types of instructions that are given? If you are telling the worker when, where, and how to work, that factor favors a finding that they're an employee and not an independent contractor. And I may have forgotten to point this out, but I think I said that at the very beginning. None of these factors are outright controlling. So if you are giving instruction to these workers, but none of the other factors are met, we're really looking at, how many of these factors, and we have to weigh it out and say, well, three of the factors point to somebody being an employee, but 15 of the factors, 16 of the factors point to the person being an independent contractor, and there's a couple in the middle that are maybe a little unclear. Well, if the great weight of the factors indicates they're an independent contractor, then, you're probably safe. But that is, again, one of the complexities with independent contractor classification is we don't just say this one thing. The old DOL test was probably the closest to that, but like I said, that test is dead right now. So, if the employee is given very detailed instructions or the worker is given very detailed instructions, then the worker is more likely an employee. If they're given less detailed instructions, that reflects less control, suggesting that the worker is more likely to be an independent contractor. An evaluation system for an independent contractor generally is only going to measure the end result. We don't care how they get there. As long as they get there and they make our new website, we don't really care what they're doing in the meantime. When you are giving tools and equipment so that you're basically instructing them about the way that the work has to be done, or if you're giving them training in your particular methods, those are things that would indicate that that person is actually more of an employee than an independent contractor. the second part of the test is the financial control piece. So the IRS expects that an independent contractor, a properly classified independent contractor, is going to have made a significant investment in resources like tools, training, office space. If you're hiring an independent contractor and you're sending them a laptop and setting them up with access to all of your different software, you send them a headset and a desk and a chair and all this stuff. I mean, this is not an independent contractor should come to you with all of these resources in place and be able to plug and play and do their job for you. Now, obviously, if you have, you're hiring, all my examples today are tech based, but if you're hiring somebody to come in and do a database cleanup for you, obviously you're going to have to give them access to your database so that they can do the database cleanup. But I'm talking about actual tools and training. So the independent contractor needs to have made their own investment in those resources. Independent contractors pay their own expenses. Generally, employees are going to be reimbursed for work-related expenses, but independent contractors, they're going to have unreimbursed expenses in connection with their work. So they are not going to be reimbursed for the cost of operating their own equipment. And if you are doing those reimbursements, again, that factor weighs more in favor of that person being an employee. So we want independent contractors, properly classified independent contractors, to be paying their own expenses. And again, similarity between the FLSA test, they have to have the opportunity to make a profit or sustain a loss. An employee doesn't typically have that opportunity. So if the independent contractor comes in and let's say their first bid was 50,000, you said no, we want to shave those hours off, we're going to pay you 30,000, but it actually takes more time for the independent contractor to get their work done, they might sustain a loss because they've underbid themselves on that particular project. Employees just don't have that risk of loss. They get paid typically either a salary and always the same amount, regardless of the quality or quantity of work, or they get paid their hours. So if they work a certain amount of hours, they get paid a certain amount of hours. The IRS typically is going to expect that an independent contractor is offering their services to the general public. They can market themselves and offer their services as they choose. And again, this is where I don't really love to see non-compete agreements with inside of an independent contractor agreement, because that really is violating the spirit of what an independent contractor is. And then they're receiving payment based on the task and not by the hour. I can't tell you how many times I've seen independent contractors be put on payroll where they get paid every 2 weeks into perpetuity. I mean, that's an employee. That is somebody, you're on the payroll. If you are a properly classified independent contractor, you are getting paid by the job or on a flat fee basis, or you're getting progress payments as you hit certain project milestones. Being put on payroll is to me, a big no-no. And again, none of these factors are all determinative. We're going to be looking at the holistic picture about how that independent contractor is doing work for your company. And then the last thing, and like I said, having an independent contractor agreement does not in and of itself an independent contractor make. However, as you can see, part of the control test for the IRS is there a written contract? That is really a starting point for the IRS to examine the nature of the relationship, but it is by no means conclusive. Even if the agreement says that this is an independent contractor, the IRS can still say, no, this is actually an employee. So I love them, great to have them, but they are not determinative. I have seen independent contractors be on 401k plans and health insurance and getting vacation pay. those benefits are for an employee. If an independent contractor wants those benefits, it's their job to provide them for themselves. Again, if the relationship continues indefinitely, that's an employment relationship. The independent contractor should be engaged for a specific period, for a specific project, not indefinitely. And then are the services provided a key activity of the business? If the independent or the worker is providing services that are key to the business, that says that's an employee, not an independent contractor. Again, we're a law firm, so we do law, and we don't do web design. So when we hire somebody to come in and do web design for us, they're not providing services that are key to our business. They are providing services that are needed by our business, but not that we provide. So again, looking at all of those factors, how are we weighing things? And what I typically do when I'm assisting a client with, is this person a properly classified independent contractor? I go through each one. Tell me about, do you have a written contract? Are you offering benefits? What is the length of the duration of the relationship? I say, 5 factors are here, 10 factors are here, and then we make that determination that way. Like I said, there's also, there are common law tests, and I apologize if this is hard to see. When I was preparing it, it looked a little, the type looked a little bit more clear. The Darden test is a test. It's based on the Darden case. And this is used very commonly in the context of a Title VII, ADA, ADEA, the Age Discrimination Enforcement Act, and ERISA, because all of those statutes share the same definition of employee. So if your employee sues you under, or your worker sues you under Title VII for, discrimination on the basis of race, or they sue you under the ADA for failure to accommodate, this is probably the test that most courts are going to be using in analyzing whether that person is an independent contractor or an employee. So here, what this test is looking at is the skill required to do the job. Who is the source of the supplies and tools? The work location. So again, it's a little different from the others. Where is that person performing the services? Are they performing them in their own office, their own building, at their own home? Or are they embedded within your company's office, your company's warehouse, something like that? So where are they actually performing that work? This test also looks at the duration of the relationship. Again, if it's ongoing, that's an employee. If it's finite, if it's defined, then that means independent contractor. The company's right to assign additional projects to the workers. So they are directing the work of their own employees. The extent of the worker's discretion over when and how long to work. The payment method, again, if they're on your payroll, this is bad. They should be invoicing your company, and you should be paying the invoices as you go. Is the worker able to hire and pay their own employees, their own assistants? Is the regular business of the company and whether the work performed part of that business? So again, similar to that, that type of relationship or relationship type piece of the IRS control test. Is the company in business? Do they have an LLC, a sole proprietorship, a C Corp, S Corp? Are they in business for themselves? Is the worker getting any employee benefits? Again, if they're getting employee benefits, then that factor of the test is not met, and they're probably more of an employee. And then the worker's tax treatment. If you're withholding income taxes from that worker, the common law Darden test is going to say that's a factor that looks like they're actually an employee. Because there's just not enough here, let's throw in another test, the NLRB, the National Labor Relations Board. they have their own test as well. And why does this come up? Well, this comes up because the independent contractors are not employees under the National Labor Relations Act. And so because of that, they are excluded from the National Labor Relations Act's coverage and cannot be in a certified bargaining unit. And so there's again, this is a really important distinction. If you have a unionized workforce or you are in a workforce that's looking to unionize, your independent contractors can't be part of those units. So, what are the factors here? And again, I'm not going to hit on these too much because now we're starting to get repetitive, right? This is feeling like we're seeing some similarities. So, the extent of control that the company can exercise, whether the worker has their own business, the kind of occupation, and is the work usually done under the direction of the employer, the skill that's required to do the job, whether the company supplies the tools, the length of time of the engagement, the method of payment, whether the work is part of regular business of the company, whether the parties believe they are creating an employment relationship, and whether the worker is in business for themselves. So again, they're all different, but you're getting some flavor and some sense for overlap and where if you're riding the line between these folks that we have as classified as independent contractors might not be, there may be some ways that you can change that working relationship and more comfortably classify that individual as an independent contractor. You might also do some assessments and be like, oh my gosh, we got to walk this back. We need to hire these folks on. We'll talk about that in a little bit too. Then, because it's again just not enough fun for all of us, there are also different state and local tests. There's not a ton of these, so don't freak out too much. But you know, could this be an area that is expanded upon? Could other states take it upon themselves, including Minnesota, to create their own even more difficult to classify them as independent contractors? Yes. I mean, I definitely think that that is something that could happen. New Jersey, in a case called Hargrove versus Sleepy's, the New Jersey Supreme Court concluded that companies have to analyze an individual's employment status separately under state wage laws and the FLSA. And so when making the determination under New Jersey law, it's the ABC test that begins with the presumption of an employment relationship that then the employer has the burden of overcoming. That ABC test, it's ABC because it's the absence of control, the business of the potential employer, and what activities are they customarily engaged in. So if the worker has been and will continue to be free of control and direction over doing their work, independent contractor. If the work performed is outside the usual course of business for the company or performed outside of any of that company's place of business, then that person looks like an independent contractor. And then C, customarily engaged, is the worker customarily engaged in an independently established trade, occupation, profession, or business. So ABC, love it. So if you can, the presumption is that they're an employee. The employer can overcome that by meeting all of those pieces of the ABC test. California codified AB5 based on the state Supreme Court's adoption of an ABC test in the Dynamex case. An independent contractor in California is an anomaly. So very, very, very difficult to properly classify somebody as an independent contractor in California. If you have people in California, certainly this is something we need to talk to you about. Tucson, Arizona also has adopted the ABC test. So if you have any employees working in Tucson, that ABC test has been adopted there. So again, we don't have a ton of jurisdictions going out, branching out, doing their own thing, but it could certainly happen. All right, so the Department of Labor. This has been a moving target for a while. It's been in flux since the Trump administration. So way back in March of 2021, the Trump administration adopted a rule, and that rule was delayed and then rescinded by the Biden administration. There was a new proposed rule that came out in October 2022. It got something like 55,000 comments from people saying, yes, we love this test. No, we hate this test. So obviously that it took a long time to sort through all of the comments that were received, and that final rule was published on January 10th of 2024 and went into effect March 11th. There are some lawsuits about this particular test that are underway, but we don't have any indication that this test is struck down for now. And there's a lot of differences. So remember I said with the other tests, there's no one factor that's determinative. Well, in the Department of Labor test, which, would apply when we're talking about a whole host of different types of lawsuits, anti-harassment, anything that the Department of Labor is going to have purview over. There were two core factors, and then there were additional guiding factors. So there were 5 factors, but it assigned more weight to the 2 core factors. And those covered the nature and degree of control over the work and the worker's opportunity for profit or loss. So if you left them alone and they could profit or loss off of the work that they did, well, that was really a strong indication that that person was an independent contractor. And then these additional guiding factors, the amount of skill required for the work, the degree of permanence of the relationship, and whether the work is part of an integrated unit of production, those were the sort of side guiding factors. All right, 2024. Now, what are our new factors? So we've tossed out the idea of the core factors and the guiding factors, and now we are back to having no one factor be dispositive. The weight given to each factor depends on the facts and circumstances of each particular relationship. There's no predetermined weight. This is true even with the control factor. The 6 factors are not exhaustive. I don't know how else to say it. Nothing matters here. We got to look at all of it, and we have to look at all of it in each specific case of each specific independent contractor. We can't lump everybody together because everybody is going to potentially be doing something different. So these 6 factors, opportunity for profit or loss, and that is dependent on managerial skills. So what is that? What in the world does that mean? I mean, that means that it has to be their skills in running the business, in hiring, firing, the managerial component. What are the investments by the worker and the potential employer? This is about tools. What is the degree of permanence of a relationship? What is the nature and degree of control? The extent to which work performed is an integral part of the potential employer's business, and what is the skill and initiative of the worker? So now we're essentially looking at a totality of the circumstances analysis, and it's kind of haywire. So we had a core factors, those are gone. I think this increases the risk that many workers are probably going to be classified as employees. The lack of a key factor is going to increase vagueness, which will just lead to more litigation. And of course, we don't know how the Department of Labor is going to use this new rule as part of their audits and enforcement. So what are the next steps? We've got about 5 minutes left here. I can't stress enough the importance of looking at your independent contractor relationships and your procedure for engaging independent contractors, because odds are there's probably some vulnerability here and there. Even if you've got 2 or 3 properly classified independent contractors, if you've got one that is improperly classified, I mean, again, we talked about the penalties at the beginning. You don't want any of these agencies in there looking at your contracts, anything like that. If you don't have an independent contractor policy in place, you might want to look at that. That would be an internal policy that specifies best practices, the contracts are to be entered into, the type of relationship that's to be formed, how you're going to invoice, all of those, the nuts and bolts of how you're going to contract one. If you've got an independent contractor agreement already in place, start thinking about some of these new Department of Labor factors. And also, you might need to look at, do you have non-competes as part of those independent contractor agreements? Because in Minnesota, those are banned as of July 1st anyway. Even for independent contractors, they're becoming way more disfavored in other states as well. So not a bad idea to take a look at that. You may want to consider changing certain worker pay structures or shifting some workers to employee status. This is fraught with danger. Changing somebody from an independent contractor to an employee it's a tough time, and this can be something that triggers an audit or somebody to go out and file a complaint, because if they get wind that they've been improperly classified as an independent contractor and they know how much they were working, and they have all this overtime and they were being shorted in pay by you, this is where I get heartburn. So if you're looking at possibly having to reclassify somebody as an employee, you want to engage legal counsel as much as possible to do this under the auspices of attorney-client privilege, and find ways to communicate this to your or to your workers that were improperly classified. Maybe you add more job duties. Maybe you modify the terms of the way that they were performing the work for you, to couch it in a bigger change or something like that. So this is where we're sort of, at issue, and where we're really in the danger zone, as if you're having to reclassify somebody. So I just wanted to get this last slide up. If you have questions, this is Chris's information at Asset HR. Sophie, did we have any questions come in?
Hi, yes, we've got one open question. The question is, if you make them employees, can you hire them as a classification that is not eligible for benefits, such as part-time, temporary, per diem employee? 401k may depend on hours worked, i.e. 10 or 1,000 hours.
Yeah, I mean, I think you can hire them as in that classification. Now, just because they're not eligible for maybe health insurance or a 401k, if they're an employee, you got to do all the same other things that you would have to do for any other part-time employee. So withholding income taxes, paying for unemployment, workers' compensation, they have to be included in numbers for counting toward FMLA, toward the ACA. All of those things, those part-time folks are going to be counted in that number, for purposes of, your employee counts as well. So you have to still give them the statutory benefits that they're entitled to. But yeah, maybe they're not eligible for vacation, but if you're in Minnesota, they're part-time, they're eligible for earned sick and safe time. So that could help with a few benefits, but there's still some things that are going to apply even for part-time folks. Good
Thank you.
question.
Thank you,
Yeah.
Janelle.
Mhm.
So far, that was the only question we had, unless someone else wants to raise their hand and write one in real quick. We have got a little bit of time. We could answer another question, or else we'll let you all go.
Yeah, and if you're already a client, certainly feel free to reach out to us. We can talk to you about any existing independent contractor agreements you have in place. If you're thinking about contracting with somebody and you want to, have us do an analysis of that, we can help out with that as well. The point is, you're not alone in having to make these decisions, so you can reach out to our team anytime. And if we don't have any other questions, we'll go ahead and end the webinar for today, and just thank you everybody for joining. I hope this was helpful, and we'll see you at the next one.